Welcome once again to Lehto's Law. Here's Steve Lehto.
I was watching my inbox yesterday and an email came in and the headline looked familiar. And I thought, I've already done that story. And that happens from time to time where people missed a video of mine and then they see an interesting story and they go, Steve, did you see this story? And I say, yeah, I did that story a couple days ago. And I'm sorry, I just hadn't seen it. No problem. I got no problem with that. I'd rather have you err on the side of sending me something hoping that I'd like to see it as opposed to not sending it and me discovering that, there's a story I missed. So here's the thing. This story was just eerily similar to one I did not so long ago. Nevada casino to pay $8 million for serving chemicals, not beer. And you're going to go, wait, chemicals, instead of the drink. Interesting. So yes, it's another story I did. We'll talk about that in a second. But this story here, as reported by WEAU, 13 News, and the Associated Press out of Las Vegas, a jury in Vegas has awarded $8 million to a middle school special education teacher who filed a lawsuit after being permanently injured after being served cleaning solvents instead of tap beer at a casino bar. Walks up the bar, says, "What do you got on tap?" "I'll take one." They give him something, and it's a glass full of cleaning solvents, not beer. That's not good. The man is 38 years old, used to work also as a wine steward at Las Vegas Strip restaurants, but lost his sense of taste due to this injury that happened back in 2018, according to his attorney. And that's one of the things I always have to explain to people, that a good lawsuit needs to have two things, and think of them like numbers being multiplied together. There needs to be liability, that is the other party's at fault and has harmed you, and then the harm must be something that can be seen and recognized and monetized. And so I've had people tell me, Steve, the craziest thing happened to me. And they tell me a story and they go, "Were you hurt?" And they go, "No, but I could have been hurt." Okay, you could have had a lawsuit too, but without damages, you got no lawsuit. I've also seen situations where somebody's got a huge amount of damages, but no liability. So think of either one of those. If one's zero, you get nothing. It's got to be a solid number times a solid number, okay? If one of those is a zero, you don't get anything. So here's a guy who can actually say, I need my sense of taste because I'm a wine steward. And without that, that's going to screw things up. Also, would you want to live the rest of your life with a messed up sense of taste? So that is a serious problem. The man who was the plaintiff here has a PhD, and he continues to teach and coach basketball. But he has stomach and esophageal ulcers and is at an increased risk now of cancer, according to his attorneys. The attorney characterized the jury award as compensation for the loss of enjoyment of life. Different states will have different things for which you can and cannot be compensated for. Also, what varies from state to state is whether or not you can get punitive damages. But here he's saying that he was actually being compensated specifically for the fact that there are things in life he can no longer enjoy. A spokesperson for the casinos, which is the corporate parent of this particular one, did not immediately respond to messages about the verdict that was reached on March 18th, it's a little over a week ago, in Clark County District Court. For those of you doing the math, they probably do have time within which they can file an automatic appeal, meaning that they can file the appeal and get it heard by a higher court. Usually you get that first appeal as a matter of right, and then after that you've got to get permission. But that first appeal, and it depends again on the state and the court system, can be anywhere from 21 days to 30 days, but it's generally a few weeks to give you time to think about whether you want to pursue it as an appeal. And quite often they go after the larger awards and say, well, that award is excessive. So the attorneys here said that the bar actually admitted liability and had offered to settle the case before trial. And the unusual thing about this story is it actually gives a number here, and it says that they offered $300,000 before trial. And quite often, settlement negotiations are confidential. And in a case that I would have had, if I'd had a case where I got some big jury award, I'm not sure I'd be talking about offers that were made before trial. So I'm not saying there's anything necessarily wrong there. I'm just saying it's a little unusual that somebody comes out and says, yes, here's what we were offered before trial. I've seen this before. I've seen it before, but it's less common than hearing about the jury verdicts. The lawsuit said that he was sickened, referring to the plaintiff, and experienced convulsions after he asked for a sample of a particular brand of ale on tap and instead was served caustic chemicals commonly used to clean beer taps and lines. His lawyers said that the bar employees knew the beer lines were out of service because they were being cleaned. And so for whatever reason, somebody who didn't get the memo, as they say, said, oh, here you go, and did a pour and gave it to him, and he tasted it, and it turns out it was actually cleaning solvent. And so that is a very serious issue. The story that this reminds us of, if you're a follower of my channel, was back in January, where Cracker Barrel got sued and a jury awarded the plaintiff there $4.5 million. And the person had been served cleaning solution as well. And that was in Tennessee. And it was a $4.5 million award. And this guy here gets $8 million, at least as far as the award goes. That's assuming it doesn't get appealed or reduced or anything like that. And for those of you who are curious about the procedures here, quite often in a trial ends, a verdict comes out, you have the verdict. The verdict gets reduced to a judgment, meaning there's an actual piece of paper labeled judgment. And that piece of paper then becomes very, very important because it's the judgment. It's the thing that says that you got this money. Quite often, after a judgment gets entered, before somebody files an appeal, they've got the right to ask the court to reduce the verdict. And it's called a JNOV, where you can ask for a judgment notwithstanding the verdict if the jury made a mistake in a way that was so obvious, or if the court had made a mistake that was so obvious. And I know a lot of people, including myself, find this problematic because I think once you hand it to a jury, the jury does what they do and they hand it back to you. And I think that the jury should be given great deference for what they do. However, let's suppose, for instance, that you have a case where the plaintiff can show and blackboard, they call it, actually put up numbers, and can blackboard $100,000 in damages. Let's say it's a contract case. Very, very easy to do the math. So plaintiff comes into court and says, I need $100,000, breach of contract, I can prove it. Here's how I come to the number, $100,000. Defendant comes into court and goes, we don't owe that money, never breached the contract, we owe them zero. But for some odd reason, the jury gets really, really pissed off at the defendant. And that happens, it happens. They also get pissed off at plaintiffs sometimes too, but they get really pissed off the defendant. So instead of awarding $100,000, they award $100 million. Well, in that case, where the plaintiff asked for $100 and at most was entitled to $100,000, when the jury comes back with $100 million, in that case, I think a JNOV is correct because they clearly exceeded what was even being asked for. But again, that's a very unusual circumstance. It doesn't happen often. Very good friend of mine, though, tried a case in Wayne County Circuit Court. It's a lemon law case. One of my friends who does lemon law. And they had gone before the jury on several different theories, one of which was lemon law. But they thought, well, in case the lemon law is not quite perfect on all counts, we'll bring a case, a cause of action also under the Magnuson-Moss Warranty Act, which has similar remedies. And then they also brought a case for breach of warranty under the UCC. And they brought a case for the Consumer Protection Act because back then it still existed in Michigan. And so he had, I think, 5 or 6 different counts, any one of which would have gotten his client back the full value of the car, and the car would have gone back to the manufacturer. And the jury got really angry at the manufacturer and actually said, my friend's client wins on every single one of the 6 counts, and each count gets him the full value of the car. And the car goes back to the manufacturer. And of course, my friend's client's not entitled to 6 times the value of his own car. He's entitled to the value of the car or the cost of the car. But that one did get reduced later, JNOV, or it may have settled, I'm not sure. But the point simply is that you can sometimes see where the jury's made a mistake. But when you put somebody with injuries, physical injuries in front of a jury, and they get up and they testify and they say, look, here's what happened to me. Here's how I feel. Here's the situation. Here's my doctor. And they will often tell the jury, here's what we think this is worth. We think this, missing arm is worth this much, or these burns are worth this much, or a loss of employment is worth this much, whatever. And sometimes juries will exceed that. And who's to say they're wrong in that case? Generally speaking, the first thing you do is you ask the judge to reduce the verdict or throw it out or grant a new trial. You say there's mistakes made in the trial that warrant giving us a brand new shot at this. If that doesn't work, then from the denial of that motion, your appeal period starts to run again, and then you can appeal. So we'll see what happens on this. And by the way, just to show you that I can legal up anything, some people are wondering, is there some more legalese we can learn here in this case? You walk into an establishment that serves food and drink for consumption on the premises. You walk into a restaurant. You sit down and you order food. They bring you something which you are planning to ingest, whether it is food or drink, and it is not safe to eat and you eat it, and you get injured as a result. You can go after them for breach of the implied warranty of merchantability. And the implied warranty of merchantability is the concept that something will do what it's intended to do. That is, a car will get you from point A to point B safely and reliably. A refrigerator will keep your food cold. A lawnmower will mow your lawn. So food to be consumed on the premises at a restaurant should be fit for human consumption. It's a really low bar. And we've all heard stories about people go places, eat something, and get sick. And if you can prove that what you ate got you sick, then breach of the implied warranty of merchantability with respect to the food. And so what often happens is you hear about like E. coli outbreaks and things of that nature. And it's simply a matter of whether you want to go through all the hassle to try to get compensated for being sick for a little while. And the question is how sick you got and how long you were sick for. I've never had E. coli, so I can't speak to that. But I've also heard of class actions being brought against places where there was an outbreak of people who got E. coli. So that's another story altogether. But again, it's the implied warranty of merchantability, which comes from the Uniform Commercial Code, because this is, in fact, a form of a sale of goods, and that is food to be consumed on the premises, i.e. at a restaurant. So there you go, Nevada Casino to pay $8 million for serving chemicals, not beer, from WEAU, 13 News, Whoa News, and the Associated Press. Jason sent it, thanks a lot. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Sunrises and sunsets are my escape into the reality I want to continuously live.